So let's just do this now with this Steve Barratt, barrister. Now, this guy is a qualified barrister, and he does social media now, and he goes on like The Spectator, and Michael Gove's going to be in charge of that Spectator now. Look, this is just an example, right, of how these people who are approaching this from being on our side, like Steve Barratt, he's saying that he wants to protect juries. So that's what like the campaign group Defend Our Juries want to do, protect juries, right? And he's going casually on his programme, but casually as a professional barrister, and he's putting stuff out that his eager audience are kind of like just, we're listening to, and then going away from it as if it's like the truth and correct, but he's wrong. On this point, he's wrong, and this is a really important mistake. And I know that, I like Steve Barratt. I think he's a good guy, and he's on the right side, but he's putting things out that are wrong. Now, if I do anything wrong, I'm not a professional barrister, and people don't take what I say as the truth. Like, they don't accept me as any qualifications, which is why I'm not getting on any channels, right? Even just like audio interview, right? No one will have me on. Yet there's all the important things that needs to be said and needs to be known, right? Now, this is a really important mistake which he's made, because he gets the whole point of Parliament completely wrong here, right? Now, I'll just play this little short bit, right? I think it goes up to, and we're on 1 minute 32, and I think it's about 1 minute 46. So I'll pause it after he's finished saying it, right?
It's a very old offence. It's called a common law offence, which means it arose before we started to really use Parliament to make laws. Back in the day, Parliament just raised taxes and levies. That's
right. So he's trying to make out, right, that Parliament was only there to raise taxes and levies. That is just not true. It isn't true. It's not the case. It is not right. Parliament is not there just to raise taxes and levies, right? The king, when he needed to raise money and levies, used Parliament and the Commons, but Parliament was called primarily to redress the grievances of the people, because they were getting them. They could get them redressed to the king through the observation of due process, 1368. Or through the courts. If you've got a dispute with a judge in a legal case, you could use a bill of exception or a writ of error to the king, right? That was a redress of grievance. You didn't need a parliament for that. But when they had parliaments, then you had your MPs to represent you instead. So you didn't need to represent with the King and Council. You got your MPs to do it in Parliament and actually vote on things on behalf of the people, right? So it's not there for raising and levying taxes. It's there for redress of grievances. Now, John Pym explicitly states this in the 1640 Short Parliament. Why are parliaments called? And the main part of it is redress of grievance through petition, and only part of it is amending and strengthening the laws and changing and raising taxes. Now, this is the thing. Local councils could get orders to raise money locally, right, through the King's Justices when they went round on the circuits, right? So you get permission to build cottages at the assizes with a jury. You get permission to raise money for the roads, and particularly for the main roads like the King's Peace roads, right? You had to give it at the court, right? And those are the King's Justices going round, if they wanted to raise money for that. It was the king who actually wanted to get permission from the Commons to raise money for the king himself, not necessarily for areas, because you only can really do certain things by acts of law, but they did actually raise money in local areas. You didn't actually need a parliament in place. You could raise tax and monies through local jurisdictions in the courts, because the jury would decide on it for fixing roads and all kinds of different things. You had like fixing walls and all sorts, right? So if every local area could have decisions with the King's Justices, right, you didn't need a parliament. William Prynne goes through the entire rules of Parliament in great detail because he wants to find out why parliaments were formed and where they originated from. And actually, they originated from the bishops and the abbots, not from the barons and knights. The barons and knights were having these grand councils, while the bishops and abbots were having more what was they used to call the Parliament, and then they kind of joined together and merged, according to William Prynne. Now, this is important what Steve Barratt says here, because Steve Barratt is meant to be kind of like advocating on the right of a lot of these political causes which are opposing Starmer's government, and I've tried to get him interested in privileges and, you know, the petition for leave of court and all these things, but he doesn't necessarily seem to be responding. He's just called out the Attorney General, but it was on something else. It was on Nigel Farage and his like past past opinions when he was a kid at school, right? You know, the Attorney General's been saying things about Farage and his opinions, right? So he's still not actually, even though he's called the Attorney General out, he hasn't called the Attorney General out on what he needs to be called out on, right? Now, when you're an influential barrister and you've got, I'm just going to check to see how many. He's got 83,100 people watching him on 135 videos. And on his Substack, which he says is his pride and joy, he's got 6,000 people, right? Now, he's not going to re-upload this video. And, I know it's not nice to do, nasty things to people, but this is the thing, right? If I wanted to flag and report this video, he's wrong in this video, and he's getting accolade and attributed as a professional barrister who, whose opinion is meant to be believed and correct, right? And he's going to courts and doing cases. If he's saying things like this that aren't right in this video, what about his court cases? Now, I think, I like him. I think he's great. If you report this video for misinformation, it won't get taken down because it's got to be over particular things, and legal misinformation isn't on there. You can put a legal complaint in, but you've got to sign it and back it up yourself and put all the legal arguments in there. I don't know what it takes to get videos taken down these days, but this is the thing. It's like, I don't really want to get his videos. I don't want to get his videos taken down, or, but he is misleading people and putting misinformation that is wrong in a time when it needs to be correct and right. Now, why is it important is that the part of Parliament, which is meant to be half of Parliament, 50, it's meant to be as much for redressing grievances as much for amending and strengthening the laws. And they've gradually pushed us and our petitions to the side and reduced the importance and tried to make out that it's not important. And then, tried to near enough eradicate paper petitions and set us up on the e-petitions in which they're censoring and obstructing with a policy which goes against standing orders and totally censoring us, right? And Parliament is meant to be there to redress grievances equally as much as amending and strengthening laws. Now, this is where the Labour Party and the Tories just don't care about us at all. They're not interested in our private personal claims and petitions. They pretend there's some engagement, we're doing committee investigation on digital ID, we want people to submit written evidence. That's just, it's all it is now is a goodwill gesture because, it's like local councils with public consultations. They do a public consultation just to make it look like they care about what the public says, but they don't have to act on what people's opinions are in any majority or anything, supposedly, on those public consultations, right? So, now, if Parliament is, and it is, meant to be as much as for amending and strengthening the laws, equally as much as it is for redressing grievances, then it would mean that there was an equal part for redress of grievances. But now, all Labour exists for is getting their business through and getting their MPs to vote on it, and no matter what, at all costs, and making it look and sound like there's some sort of, if we get 100,000 signatures, we can get ourselves a debate, or we can contribute some sort of written evidence to their committee investigations, which likely doesn't amount to much. Unless you're doing a private bill and you're a really big expensive company that's got hundreds of thousands of pounds free and it can pay for a parliamentary agent to help it, write an act of law and get it sponsored and all that. And then, they take that more seriously and legitimately in upholding the rights that you use with that. But they're not even upholding our rights. Now, with parliamentary privilege and immunities from prosecution, it's so important because it's not just your elected MPs who go and work and talk in Parliament and debate in the chamber who have protection. It's people who have causes and matters to Parliament. Causes and matters to Parliament and pursuing those, right? Advocating those, making a civil process for those in our proceedings when we pursue independent causes to challenge Parliament. And that is for redress of grievances. And it is as equally as important and it's meant to be why Parliament's called equally as much as amending and strengthening the laws. But they don't strengthen the laws. In fact, they're stripping and breaking down the laws at the moment. They're trying to undo the Constitution and the laws, right? So when Steve is not acknowledging in this casual statement here that Parliament is there for the redress of grievances and our privileges, our privilege processes, as much as the MP going in there for amending and strengthening of laws, he is severely misleading people. And he's actually not advocating for our rights and what the point in Parliament is, and even that we've got a whole area of law for that, right? He's completely omitting that part from his statement, which it's important and serious. Now, here's my little notepad part on this, right? I put at 146, legal misinformation. He says, back in the day, Parliament just raised taxes and levies. But it's wrong. It's wrong. Parliament is primarily there to redress grievances, which is confirmed in the 1640 Short Parliament and earlier, right? Now, this is actually what it says in the Bill of Rights here, which I'm going to highlight. Now, this is what the part I've highlighted there. This is in the 1688 Bill of Rights. And remember, parliaments weren't even frequent, right? They weren't even frequent. It says that frequent parliaments are called, and that for redress of all grievances and to the amending and strengthening and preserving of the laws. Parliaments ought to be held frequently, right? So it's as much, and in fact, if amending and strengthening and preserving of the laws was the main reason and priority, why would they write in the 1688 Bill of Rights, the Constitution, to the reaffirmation of the Constitution, why would they put redress of all grievances first and then for the amending and strengthening, preserving of the laws, right? If it was less important, why wouldn't they write it in the opposite way? Why wouldn't they put for the amending and preserving and strengthening of the laws and redress of all grievances, right? They did levy money in Parliament, right? And they did alter taxes, but they didn't have to. They didn't need to have parliaments for that because you could... They got money from the Crown through the courts, through the judges in local areas to a certain extent for certain things, because they got taxes, right? They had taxes, right? They had a taxation system, so people were getting taxed, right? It's not like you don't have tax, like it goes away. It's not like taxes go away and they don't exist, right? And then we'll have a parliament and have some more. They're like, taxes are there in between parliaments, right? Now, how that tax money gets spent, you can have court hearings about what should we spend the money on, or can we use some of the money for this or that, right? Like for roads and so forth, right? Now, it was really when they got the House of Commons, they wanted to control how much money the king had himself, right? You know, this is to do with all. He wanted to put some money for building ships, like ship money, and you know that's why there were a lot of arguments leading up to the Civil War, right? Shipping money and to build the fleet, you know, to fight the Spanish, etc. If you believe that, you know, if they weren't just plundering. You got Francis Drake and so forth going out on ships, you know, as pirates, effectively. But anyway, so Steve, when a professional barrister is making videos and going on GB News talking about the Attorney General, you know, being a disgrace to his office and all this and that, and he's talking about, you know, why is there a parliament? If he does not tell us that one of the primary and main reasons you have a parliament is for redressing the grievances, and how do you do that? Well, the people do it by causes and matters to parliament, by a matter of writ or record with the observation of due process of law, and after 1688, the 1688 Bill of Rights as well, right? And we use special, not the common law. It's under the law of Parliament, which is privileged, and that is completely and totally affirmed in the Bill of Rights. But it was meant to imply anyway, before the Bill of Rights, it's just that the king used to prosecute people. We didn't get prosecuted through the common law in local areas for petitioning. It was only the king who would prosecute people if he didn't like the religious opinion. Because if you're doing a matter to Parliament, it's not under the local courts and common law. That's the thing. It's under the law of... you know, if it's to the King, Council or Parliament. And this is when it's under that jurisdiction, and the king was prosecuting people under that jurisdiction. It wasn't under his local justices or courts. It was like the Court of Royal Commission or like the Star Chamber, etc., right? So it's so important because Steve is not acknowledging one of the main purposes that Parliament exists, and one of the main, the law of Parliament. But you don't even need the law of Parliament. The 1688 Bill of Rights gives you privilege and protection just to have matters and causes directly to the king if a Parliament isn't called, and if you don't even have any MPs anyway. But none of these barristers will acknowledge that law, the law of privilege. It's constitutional law. I don't know why it only gets acknowledged as the law of Parliament, like in Erskine May, because you didn't always have a Parliament. It's actually called constitutional. It's constitutional law. That's what it is. And this is what Graham Moore's talking about, right? And this is when you get books like Herbert Broom, like the common law in relation to the constitutional law, right? And I don't actually think... I'm quite certain that Steve Barratt doesn't really know that law. I don't think that he properly actually... I don't think that he's come to the actual revelation on it or insight. I don't think he's had the eureka moment on it yet. I still don't think that he understands or believes in it as an actual legitimate full entire area of law, with a really important importance in when you call a parliament, when you don't even need to call a parliament for this area of law because you've got the 1688 Bill of Rights. But even before the 1688 Bill of Rights, the observation of due process of law makes it a proper area of law, and through the courts, because if you call a Bill of Exemption on the Statute of Westminster II, the justice has to sign it, right? The justice has to sign it if you disagree with the justice, and then you're petitioning the king there, and the justice is compelled, right? You are compelling the justice, right? And that's actually a statutory power that you had, and that was, the Statute of Westminster II. What is it? It's after Magna Carta. I think it might have been around the second when Magna Carta was reissued, 1275. I think it could have been 1285 or 1275. It was either just before or just after Magna Carta and the confirmation of the charters, the Statute of Westminster II,